Get ready, start. The decision of the Ministry of the Police Authorities may not be correct, but that ipso facto would not be a ground for the court to believe that it was a colorable or mala fide exercise of power. Stop. Para. Now, I may refer to the case put forward by respondent for the President of Bharat Swabhiman Trust Delhi area who has filed affidavits on behalf of that party. Stop. At the outset, it is stated in the affidavits filed that Baba Ramdev, the trust and his followers are law-abiding citizens of the country and never had any intention to disturb the law and order in any manner whatsoever. Stop. Ramdev various campaigns and meetings have been held by the trust in various parts of the country and all such meetings have been peaceful and successful as well. Stop. Baba Ramdev had been traveling the length and breadth of the country explaining the magnitude of the problem of corruption and black money and failure of the government to take effective steps. Stop. The anti-corruption movement had been at the forefront of the meeting held by Baba Ramdev at different places. Stop. Baba Ramdev is stated to have participated in a meeting against corruption at Jantar Mantar on 14/11/2010 where more than 10,000 people had participated. Stop. Similar meetings were organized at the Ram Leela Maidan on 30th 1 2011 and 27th 2 2011, which also include a march to Jantar Mantar. Stop. None of these events were perceived by the government as any threat to law and order, and in fact they were peaceful and conveyed their theme for anti-corruption. Stop. Para. On 4 May 2011, Baba Ramdev had written a letter to the Prime Minister stating his intention to go on fast to protest against the government's inaction against bringing back the black money. Stop. This was responded to by the Prime Minister on 19th May 2011, assuring him that the government was determined to find the problem of corruption and black money in the economic and illegally deposits in the foreign country and asking him to drop the idea of going on a hunger strike till death. Stop. On 20th May 2011, the trust had written a letter to the police seeking permission to hold a fast unto death at Jantar Mantar, protesting against the government's inaction against corruption. Stop. The finance minister had also written a letter to Baba Ramdev on 20th May 2011 regarding the same issue. Stop. The dates of applying for permission to hold yoga camp and to hold dharna and Jantar Mantar and dates of granting of such permissions are not in dispute. Stop. The above notice dated as of applying for permission and to hold dharna at Jantar Mantar and their consequential approval are not disputed by the respondent. Stop. Para. According to this respondent, the police had attempted to make a huge issue that the permission granted to the trust was to hold a yoga camp of approximately 5,000 persons and not a fast with thousands of persons attending. Stop. It is submitted by this respondent that police was concerned with the maintenance of law and order, free flow of traffic, etc. Stop. The use of land was the concern of the owner of the land, in the present case Municipal Corporation of Delhi bracketed MCD. Stop. The trust had applied to MCD requesting it for giving on rent/lease the Ram Leela Maidan for the period commencing from 1 June 2011 to 20th June 2011. Stop. Before grant of its permission, MCD had written to the trust that they should obtain NOC from the Commissioner of Police, Delhi, which was duly applied for and as already noticed obtained by the trust. Stop. Para. Time prescribed by the court under the decree under an extraordinary circumstance of an order of injunction issued in other case. Stop. The learned counsel for the judgment debater petitioner would contended that when there was a direction for payment of sale consideration within 2 months, it was irrelevant that there was any order of injunction in the suit filed by Dalbir Singh. Stop. The deposit ought to have been an independent obligation for the decree holder to have confirmed to, and he could not have an excuse not comply with the terms of the decree. Stop. The council would rely on a judgment of this court in Chanda versus Ratni, wherein a similar situation containing similar directions in the decree that the defendants bracketed vendors shall execute the sale deed on payment of balance of sale price and get it registered within a period of 2 months, and when the decree holder did not make a deposit of obtained a sale deed or an application had been filed for rescission of the decree and that application had been allowed. Stop. The court observed that the defendants oblique vendor had the right to ask the court to rescind the decree containing a direction to sell because of default committed by the plaintiff. Stop. This judgment was a subject of appeal to the Supreme Court that there was disposed of under the same cause titled Chanda bracketed dead through LRs versus Ratni and another AIR 2007, which held that if the vendee was not paying the amount within time, the application by the vendor to rescind the contract was justified and the court was not in error in allowing for such an application. Stop. According to the council, this decision of the Supreme Court confirming the judgment of this court in Chanda squarely answering this situation that arises in this case. Stop. Para. One important fact must be borne in mind. Stop. The decree that granted the relief of specific performance for execution of a sale deed did not specifically give a direction that the amount must have been deposited within any specific period. Stop. The council would argue that this does not really make a distinction, for a similar recital was what was considered in Chanda. Stop. A decree passed by the court on a contest could not be easily interfered with or tampered otherwise than in the subsequent proceedings in higher forum. Stop. A decree again cannot be rendered affected by a supervening event unless there had been a clear breach. Stop. Ideally, in a suit for specific performance, the court shall make a positive direction for deposit or payment of amount within a particular date in court. Stop. It may seem like mere quibbling with semantics that the direction given to the judgment debater must also be taken as an inherent direction to the decree holder as well. To deposit for a sale deed could not have been executed within 2 months without a deposit or payment within 2 months. Stop. At least I am here to point out that the decree did not contain appropriate words that could have directed a deposit within a particular period, even if for some reason the decree holder could not have obtained a sale deed from the judgment debater. Stop. In this case, the decree holder could not have obtained a sale deed and there could be preceptive action for disobedience of an order of injunction that had been granted against the judgment debater in the suit filed by Dalbir Singh. Stop. No such contemporaneous difficulty exists in the suit in Chanda decided by the Supreme Court. Stop. If the decree holder therefore had not demanded the judgment debater to execute a sale deed, he would not be taken as violating the terms of the decree. Stop. On the other hand, he was abiding a restraint order which had been issued against his vendor from selling the property stop. A restraint action against the vendor from selling the property should also be seen as his own inability to secure a sale from a person who had been judicially restrained stop. A decree holder could not have secured a sale deed so long as there was an order of injunction, or if that was the perception that the decree holder held about the order of injunction that was issued in Talbir Singh's case. I would take the explanation given by him as perfectly tenable stop. Thank you guys.